People versus Martina Smith.
The water assistant prosecuting people.
Good afternoon. May it please this honorable court.
Breakdown in the relationship is courtroom code for client doesn't trust their attorney. But here's the twist. Judges don't automatically grant new lawyers just because a defendant is uncomfortable. There has to be a real legal reason.
Reem Johnson, on behalf of Martina Smith, who's approaching to my immediate right.
Your name?
Martina Smith.
All right. And what are we doing?
Your Honor, the defense is requesting an adjournment in this matter. There's been a breakdown in the relationship between me and Ms. Smith. She is seeking to retain private counsel.
Didn't she, other than the public defender, didn't she have an attorney before you? Or no?
No.
Okay. Maybe I'm thinking of a different case. All right. Ma'am, what seems to be the point?
Not comfortable. That might work for canceling plans. But in court, that's dangerously vague. Judges need specifics because without them, it starts to look like delay tactics.
Problem.
I just don't feel comfortable.
I don't know what that means.
Well,
Your Honor, she believes that I am working with the prosecution. I've tried to explain to her.
Excuse me? Oh, no, go ahead. I want to hear this.
I've explained to her that under Michigan's R&O statute, there are 7 different ways that you can obstruct an officer, including just talking back or ignoring the officer. We've had an agreement for HIDA. I thought we had that agreement worked out. She had me speak to an individual who I believe was her father, who indicated that he was a paralegal, and gave me his MDOC number and instructed me to actually hold the exam and let you bind it over. I refuse.
Whoa, this is serious. Accusing your own lawyer of working with the prosecution. That's basically saying your defense is sabotaged. True, it's huge. If not, it destroys credibility instantly.
To do that because I believe the prosecution would be seeking to add an additional at least 4 counts of R&O for the other officers that were there. And I told him that what I would do is I would ask for an adjournment because having additional charges added plus walking away from an agreement where she would have no record, she'd be in 25, so she needs the prosecutor's consent for HITA. I felt it was best for her to just get somebody that they feel more comfortable.
Well, okay, so first of all,
you never said nothing about
I've known
the
Mr.
charges.
Johnson a while. And what?
You never said anything about adding charges on her or nothing at all. That's not true.
See, here's what
I didn't.
I'm a bit concerned about, because now you're going to try to overtalk me. Go ahead. I'll wait. You done? Are you done?
Yeah.
So first of all, I think, because I've watched this attorney in my courtroom on various occasions doing things. I don't know how he stands there and not take offense when you're saying he's working with the prosecution and forsaking his client. Because this man would never.
Watch this closely. This is where the judge steps in, not just as a referee, but as a reality check. He's about to defend the integrity of the courtroom and shut this down fast.
Never do that. Ever. I mean, I that's what I just find kind of just crazy. And if you If he really thought it was in your best interest to have the exam, there is not a doubt in my mind he'd hold the exam. So that's the first thing. And I was right. This is now the second attorney. Because, as my staff would remind me, I was looking for the paperwork. You had Mr. Elmer before. And you basically had that same complaint. You don't get to continue to choose attorneys. So I guess part of the problem is going to be, this is set for a preliminary examination. And I understand that part of the reason that counsel is asking for the adjournment is really to save you. I am almost of the mind that you don't want to take his advice. You don't want to do whatever. Let's hold the exam. If you get charges at it, you get charges at it. That's your call. But I'm not removing him from the case. So now what do you want to do? Because we're not going to play this game.
And that's a key rule. Defendants don't get unlimited do-overs with lawyers. Otherwise, anyone could stall a case forever just by claiming dissatisfaction. Courts have to balance fairness with efficiency.
Ma'am.
Your Honor, may I?
Yes, sir.
Because of the conversation that I've had with her father, I'd humbly ask the court, if the court's not going to remove me, to just grant a brief adjournment. I've never asked this court to remove me from a case ever.
I know.
But we have somebody who has not looked at the body camera footage, advising his daughter on what to do in a criminal case in which she could walk away with multiple felonies. So I understand the court's frustration. I understand the court wants to move in the docket, but this is not her request. I am asking for, at the very least, an adjournment in this matter. So ultimately, she can have counsel that they feel confident in and make a decision that is not going to negatively affect her.
Well, people have a position regarding adjournment.
We've certainly no position regarding her counsel. People do not object to an adjournment, Your Honor. People release the witnesses because we were under the impression that an agreement had been reached, and then that fell apart. So people certainly could get the...
Interesting move here. The judge still grants the adjournment. Not because he agrees, but because the risk of a bad legal decision is worse than a short delay. That's the court protecting the process, even when it's messy.
The officers back if the court orders to do that, but under the circumstances, we would not object to an adjournment.
I'll grant the adjournment. I can give you, because it's got to go before me, I can give you next week or the 13th, I think is.
What day next week, Your Honor?
The 30th. It'd be Tuesday next week.
That's fine, Your Honor.
That'll work.
Yes, sir.
Preliminary examination in this matter will be adjourned December 30th, 2026. 9 a.m. I'm sorry, that's at 12 noon. That's before me.
Yes, sir, Your Honor.
Ma'am, I'm just going to give you a fair warning, and I mean it. I'm not playing this game with you and the attorneys. Either you're going to listen to them, or you're going to have an exam, and then the chips are going to fall where they may. If there are other charges and other things added, that's just going to be too bad for you. But if you think that man sitting next to you isn't trying to save you and put you in the best possible position, well, that's your fault. Because apparently with your law degree, and whoever else with their law degree knows more than he does. Bond will continue.
Thank you, Your Honor.
Hit my door. No, she hit my door. Huh? It was soft? No, it wasn't. I heard it.
And that's the bottom line. Court isn't about feelings, it's about strategy, consequences, and timing. Ignore good legal advice and you might win the argument, but lose the case. So what do you think? Should defendants have full control over their defense, or trust the professionals who've done this hundreds of times?
What are you trying to say, her? No, okay, that's fine. I'm not gonna make you chase her down. I'm just gonna. You do the same. Happy holidays. Okay, in the Christmas spirit, I'm gonna let it go. But then that's it. Somebody else do something. That's it. I'm not even looking for your suggestion. Just gonna be an order. Court calls the case, People versus Nathaniel Bryce.
People.
Deputy Judge Mel Lustig on behalf of Mr. Bryce.
Your name, sir?
Nathaniel Bryce.
Thank you. Is this going to be as complicated as the last case?
No, Your Honor, I expect a waiver.
Oh.
Her expectations will be met, Your Honor.
All right. So he's waiving.
He is.
Sir, is that correct? You're waiving your right to a preliminary examination?
Yes, Your Honor.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed.
Yes, Your Honor.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution.
Yes, Your Honor.
People also waive the right?
We do, Your Honor. In exchange for this waiver, there will be an offer available to the defendant to plead guilty to count 1, attempting, resisting, or assaulting a police officer, causing injury, with a dismissal of counts 2 through 4 and sentencing under item.
That's your understanding also, sir?
That is my understanding.
All right. Defendant is bound over to circuit court on counts 1, 2, with 3 and 4 following. Counsel, you acknowledge receipt of the information and waive it to you.
Yes, I do.
And how does your client plead?
Not guilty.
All right. Defendant pleads not guilty as to all 4 counts. Court will enter that plea. Pre-trial in this matter will be set for
1:30.
February 12, 2026, 1:30 before Judge Slay. And we'll continue.
Thank you.
Thank you. And happy holidays to you.
Same to you. Yes, you are. May I approach in a separate matter, Your Honor?
You may, sir. Do all this stuff myself. Almost had to chase a defendant down myself. Court calls the case, People versus James Thompson.
What was the name, Your Honor? I'm sorry.
Thompson.
Did you think I was calling your client? No.
Counsel office for the people.
Assistant Public Defender Chelsea Deals with and on behalf of James Thompson. Please state your name.
James Thompson.
Thank you, sir.
Good afternoon, Your Honor.
Good afternoon, sir.
You are sending in for APA evidence and this kind of people are unable to proceed.
I would move to dismiss.
People being unable to proceed.